or the fault is such a nature that the parties to the marriage do not want to divulge it. This is the other very important issue here. A person may be really suffering a lot of humiliation, but they don't want to put it in the public domain as such. Yet there has arisen a situation in which the marriage cannot be worked. The marriage has all the external appearances of a marriage, but none in reality. As is often put wittily, the marriage is merely a shell out of which the substance has gone. In such circumstances, it can be stated there is hardly any utility in maintaining the marriage as a facade when the emotional and other bonds, which were the essence of the marriage, have disappeared. It is also mentioned in the report that in case the marriage has ceased to exist in substance and in reality, there is no reason for denying divorce. Then the parties alone can decide whether the mutual relationship provides the fulfillment which they seek. Divorce should be seen as a solution. Well, a very interesting sentence. Divorce should be seen as a solution and an escape route out of a difficult situation. Such divorce is unconcerned with the wrongs of the past, but is concerned with bringing the parties and the children on terms with a new situation and developments of working out the most satisfactory basis upon which they may regulate their relationship in the changed circumstances. 72. Once the parties have separated, and the separation has continued for a sufficient length of time, and one of them has presented a petition for divorce, it can well be presumed that the marriage is broken down. The court, no doubt, would seriously make an endeavor to reconcile the parties. Yet, if it is found that the breakdown is irreparable, the divorce should not be withheld. The consequences of perseverance in a preservation in law of an unworkable marriage, which has long ceased to be effective, are bound to be a source of greater misery to the parties. A law divorce based mainly on the fault is inadequate to deal with a broken marriage. Under the fault theory, guilt has to be proved. Divorce courts are presented with the concrete instances of human behavior as they being the institution of marriage, bring the institution of marriage into disrepute. We have been principally impressed by the consideration that once the marriage is broken down beyond repair, it would be unrealistic for the law not to take notice of the fact, and it would be harmful to society and injurious to the interest of the parties. Where there has been a long period of continuous separation, it may fairly be surmised that the matrimonial bond is beyond repair. The marriage becomes a fiction, though supported by legal tie. By refusing to sever the tie, in such cases, does not serve the sanctity of the marriage. On the contrary, it shows scant regard for the feelings and emotions of the parties. Now, Milord 76 is important. Public interest demands not only that the marriage status should, as far as possible, as long as possible, whenever possible, be maintained. But where a marriage has been wrecked beyond the hope of salvage, public interest lies in the recognition of the fact. That, Milord, was the Central England judgment that I cited, that there is a competing public interest, if I may put it that way. There are two public interests, but both are in public interest. Since there is no acceptable way in which your spouse can be compelled to resume life with the consort, nothing gained by trying to keep the parties tied forever to a marriage that in fact has ceased to exist. Now, Milord, if you turn to 131 and para 82, this is the extent of litigation.
17 litigations against people.
And that is, of course,
good sign for lawyers.
Etc. Milord, yes, paradise for lawyers, I suppose. No doubt about it.
No, they become standardized. Most of them are really, when I say bookings, because it's like a standardization. The moment a divorce petition starts, there may be dowry cases, there may not be dowry cases. But everything is like a standard format which happens.
Well, let's not talk about how the legal profession handles these cases. I can tell you, I was beyond words. I was shocked when I was handling a bail petition in an honor killing case, and I read the application for bail. Well, the bail was being asked for a woman who is 69 years of age and a housewife, and the bail petition read the woman is. It was like she's a working woman. and refusing to grant bail will affect her employment, and so on and so forth. Cut and paste taken from some other petition and seriously presented to the court.
Court is also confronted with situations that real cases, dowry is a factor of our society. In cases that every family member is roped. So somebody who is happens to be a sister-in-law, but he's staying anywhere in the country is roped in. So this almost become a standardized format. Every to prevent giving maintenance, every woman becomes earning member, is like sitting at his home, and doing cooking and selling, and every husband runs into a penury the moment a divorce petition is filed.
Very well for the legal profession. These are not legal. Well, I've done this case in the Supreme Court of India. The case I'm talking to you about, well, the matter came in appeal to the Supreme Court, and I just told them I'd read the bail application. It's 69-year-old woman, and this man was talking about how she has to go to work every day. At that point of time, she was actually in custody. And the bail was unfortunately granted. But that's a different story. I have no regrets about the bail. But at least pleadings should be proper. That's all that I'm arguing. It's not this cut and paste manner of pleadings, And yes, I have to say, I've seen it very often in matrimonial cases. I have not seen it very often in commercial cases. Somehow people don't seem to pay any attention to matrimonial litigation at all. I don't know why. I'm not able to understand the reasons why this cut and paste happens.
I see. Sometimes the structured fees come in later in the matrimony.
I don't know, Milord. Maybe there's not enough money in matrimonial litigation. I have no idea.
Unfortunately, land acquisition, access claim tribunal, and very, very unfortunately, matrimonial matters have fallen prey to chapter.
At para 83, even at that stage, opponent does not want to divorce by mutual consent from the analysis and evaluation of the entire evidence. one more passage from this judgment. 84. The High Court appreciated that there is no acceptable way in which the parties can be compelled to resume life with the consent with the consort. Nothing is gained by trying to keep the parties tied forever to a marriage that in fact has ceased to exist. Then 86, Lord, in view of the fact that the parties have been living separately for more than 10 years, the number of performance have been initiated against the appellant, and some proceedings have been initiated by the appellant against the respondent. The matrimonial bond between the parties is beyond repair. A marriage between the parties is only in name. The marriage has been wrecked beyond the hope of salvage. Public interest and interest of all concerned lies in recognition of the fact and to declare defunct de jure what is already defunct de facto. To keep the same in the obvious conducive to immorality and potentially more than the dissolution of the marriage bond. Then, my Lord, 89, in our considered view, looking at the particular facts of the case, the High Court was not justified in setting aside the order of the trial court. In our opinion, wisdom lies in accepting a pragmatic reality of the life and to take a decision which would ultimately be conducive to the interest of both the parties.
Then page 90, para 91 doesn't stand implemented. Para 91.
Yes, the 90 part of the case on constitutionality of the facts, this court would like to recommend that the European Constitution consider bringing amendment to incorporate irretrievable breakdown of marriage as a ground for ground.
Court did make a recommendation.
This judgment comes in 2006. Maybe that's why during 2010 and 2013 we did see two bills in Parliament. But they were patchwork. They did not achieve the end that they were. However, I want to reiterate my submission. These judgments do fail to distinguish between a divorce with cause and a divorce with fault. Now, I'd like to just point out to a particular provision given the Hindu Marriage Act. What do we mean when we say fault? That's the question. So, if your Lordship sees section 23, the fault theory comes only in section 23 of the Hindu Marriage Act. My submission is that section 13 grounds of divorce are not really based on fault theory. They are based on cause theory. If you see 23 of the Hindu Marriages Act, decree in proceedings, in any proceedings under the Act, whether defended or not, if the court is satisfied that any of the grounds for granting relief exist, and the petitioner, except in cases where the relief is sought by him on the grounds specified in subclause A of B or subclause C of clause 2 of section 5, is not in any way taking advantage of his own wrong or disability for the purpose of the relief, and where the ground of the petition, the ground specified in so those are not mental incapacity, etc. Then in such case, and not otherwise, the court shall grant the relief. In other words, my Lord, it is this section which brings in the fault theory, not section 13 of the Hindu Marriages Act. That is the proposition that I'm advancing, my Lord. So, my Lord, this is more, this fault referred to over here cannot be equated, my Lord, with the cause in section 13 of the Act. That is my interpretation of this statute. So, my Lord, perhaps it would help if your Lordship could think a little bit about and articulate this proposition, that what exactly is the meaning. Although, my Lord, yes, the recommendation of this court also has been that you delete section 23 of the Hindu Marriages Act.
No, under section 23, disability is attached to person who goes to the court, because it is based on well-settled legal principle that person who has committed wrong should not take advantage of his own wrong.
The theory of coming to court with unclean hands, etc.
That's the basic principle. Under
yes,
23.
it is referred to in some judgments also. My Lord, it's a principle. But two things you keep in mind. First and foremost, the heading of this section doesn't say decree for divorce. It doesn't. It says proceedings. And my Lord, in actual fact, these provisions have sometimes been used when a husband wants a decree for restitution of conjugal rights, knowing fully well the marriage is broken down. Well, it's standard practice when a marriage is broken down for any reason whatsoever. In order to defeat the claim of maintenance, what the husband will do, he'll file a petition for restitution of conjugal rights, knowing fully well that I don't want this woman back, knowing fully well she won't come back. Sometimes court grant decrees, sometimes court doesn't, then he goes for a divorce. But even that, some courts have held, even that is not taking advantage of your own wrong. So, my lord, what exactly is the meaning of taking advantage of my wrong? Yeah, that's why I said distinguish between wrong and cause. There has to be some intent, some malicious intent, my lord, that my hands are not clean. But my lord, if I come to court with a case which is like a case and counter case, it can't be said that I'm taking advantage of my own wrong. So
how would you categorize a case where actually facts of cruelty are found?
Yes.
Now, and that person who perpetrates the cruelty.
Facts are found because the trial has been gone through.
Trial has been gone through. In the trial, it is established that there are various acts of cruelty, multifarious acts of cruelty. But yet, that very against the person claiming divorce, and that very person claimed default.
Yes, then I would say that is a public interest and public interest countervailing. Ultimately,
I'm going to fault theory. Will that not be a case of fault theory?
No, not because what is the
when you think,
that's why I said, let's go very logically. What is the
you said
purpose of
fault
marriage?
and
What
cause.
is marriage? What is the
I'm saying-
purpose of keeping it alive?
I'm saying there's a fault and cause when you're making a
Yes.
distinction between fault
So
and
cause.
cause.
You can say there has been cause for the breakdown. You can say, and I'll point to one judgment where there was cause for breakdown at the instance of the wife, and yet the divorce was actually.
Those are, I'm saying, interactive reactions which produced a breakdown. I'm just saying only from point of view of saying that no fault theory has no role. The little caveat was that there may be cases where an evidence that is clearly established that the person suing for divorce is the one responsible for all that there is. Will that not also then fall at least within the fault theory?
No, there is. If you come to the conclusion that the marriage is broken down, there's no sense in invoking the fault.
I'm not disagreeing with it. I'm not completely not disagreeing with the concept that a good, bad, or indifferent reason for a failed marriage should not perpetuate that union meaninglessly. The thing is, you can take better care. You're talking about you can take better care for financial arrangements of them. And that's it. Maybe something more than a normal arrangement would be required because you did something to cause a break to the marriage. You are responsible. Okay, then you. You better pay more for the divorce.
I'm arguing that I may be responsible for the breakdown, but that does not disentitle me to the divorce.
But I'm saying this can be worked out, the impact can be worked out in financial terms when the court considers. What are the financial terms?
All you can do is attempt a reconciliation, even if I am responsible for the breakdown. But beyond that, once the factum of breakdown is clear, then it's like this. Somebody wants to keep the marriage together, not for the purpose of consortium. That is why I started my argument by saying, let's first understand what a marriage is all about.
That consortium is over, obviously. Whether A is responsible or B is responsible. If a consortium is over, we appreciate that argument. Once a consortium is over, then it's a pointless marriage, pointless association. So it must be. So if in a commercial terms, if there are two partners and the partnership breaks down completely and the trust breaks down, then the partnership gets over. You dissolve the partnership. Not sounding so commercial, but the fact is this: if a consortium is broken down and nothing is possible, there are cases where after difficulties also reconciliation takes place. But if nothing is possible, then but the terms of settlement may be accordingly.
The only reason to reject an application is if you come to the conclusion that the marriage is not irretrievably broken down. It has not irretrievably broken down. Then Yes, there is a purpose of keeping the marriage together. But if you come to the conclusion that it has broken down, it's irrelevant who was to blame. That's basically the issue, my lord. So therefore, my lord, let's not confuse this issue by reference to section 23, because section 23 is the only. That's why, my lord, I'm also going to say that the way your lordships have framed the issue under 142 also, your lordships have asked the question, can we do it when party is not giving consent? My lord, the question of consent is irrelevant. Ultimately, it's the court which gives the divorce or doesn't give a divorce.
That's a very expanded view. Why in the first two questions frame, we did not find this issue and we wanted to do this? Because there were people who were raising an issue that even under 142 you can't do so. Therefore, we framed the question,
But I
can the
understand.
power under 142 be inhibited in any manner merely because it is not contained in the statutes? Prima facie, we thought may not, but subject to whatever arguments are advanced.
I understand that by saying the answer is yes,
The right to get divorce is a statutory right now.
it is.
And the fault is that of the person who says, I want to get out of the marriage. Then what do we do?
The only thing a court of law can do is attempt a reconciliation.
It's not in the criminal.
Beyond that, my lord, no. Other or live with each other.
You want to give full autonomy to the person to decide whether he wants to continue or not continue.
That is why I put it on the level of a fundamental right. The right to affiliate and the right to not affiliate. Subject to procedure established by law. Obviously, that is why, my lord, I started it saying because it's a judgment in re, the matter goes to court. There are systems of law where people give unilateral divorces. They exist, my lord. Even in India, there are systems where you can get a divorce by customary law without approaching a court of law, and the court of law will recognize that divorce. But there is an intermediary, in this case, the court. So the real question, my lord, your lordship have to decide is what exactly is the role of the court in a situation of this kind. That's why I went back again and again and again to saying exactly what is the purpose of this arrangement. And your lordships have also said it in several judgments. So that's why if you just separate blame and fault, maybe that's one way of looking at it. And just separate. I may say, look, I know I'm blameworthy. But what can I do? I can't make a go of this marriage at all. I'm going to say sorry. The Indian law doesn't allow it. So, that's why in one of the judgments they say, look at the consequences of saying no. What are the consequences when a court says no? And, my lord, case after case, it's all in the compilation, my lord. Every case that has come before the court, the man or the woman has married during the pendency. I'll tell you the standard cases that come to court. A decree for divorce is obtained. Before the appeal period is over, one of the parties remarries. There's a child of the marriage. The court is presented with the fiat account. And then the appellate court feels that the original decree was bad in law. No, there are reported judgments of this.
Then the status of the second woman troubles us. The status of the child troubles us.
And my lord, if I'm not mistaken, there's a judgment of they say I'll dig it out and give it to you, where this court was compelled to hold that both marriages are legal. Lata Kumar. Just try and look for that case.
And one more question I have to answer at appropriate stage. There are cases and cases where this court has granted divorce for exercising power under Article 142, though one of the parties is not consenting. But these are all cases where there was already litigation, evidence reduced, and parties came to this court.
Yes.
Now, if we accept the argument that under 142, court can dissolve marriage when it comes to the conclusion the irretrievable breakdown of marriage. So, will it be possible for anybody without approaching any court directly to come to Supreme Court and tell the Supreme Court that exercise power under 142? Because so far we have been exercising powers where there is adjudication,
I-
there is evidence to come to a conclusion that there is a breakdown of marriage.
I'm not arguing that. I'm not arguing that point. Because it is.
But that will be a sequel. Somebody may say that, look, there's complete breakdown of marriage, therefore now grant me decree of divorce.
Go on 13B and file a petition for mutual consent. No.
No.
Indian law provides.
One of the parties, I'm saying one of the parties.
Where
One of
there
the
is no
parties said
consent.
a complete breakdown of marriage
Correct.
and grant me divorce. I am coming directly to the
Yes,
Supreme Court.
what I'm saying is,
My brother
breakdown
says
of marriage.
there may be scenarios where society improves, gets better ideas from legal fraternity. So tomorrow somebody may say, look, why are you making this is torture? You're making me go through a process.
Can happen, I know.
So I can't go to court and say, look, I'm at fault, give me a divorce. So I'm being unreasonable, but give me a divorce. So I will have to, unless the mutual consent, I will have to attribute things to the other partner to prove that she is in the wrong so that I can get a divorce. Why do you make me go through this process? My partner is unwilling for a divorce, but I can't live with her. And therefore, if I can't live with her, I don't want to make allegations against her. And if I don't make allegations, the divorce can't get through. So don't make me go through this torturous procedure. I am coming to you saying, I may or may not be at fault, but I can't live with her. Please give me a degree of divorce.
There is an answer to that question, Manoj. You read the statute as a whole, and you decide whether the statute contains adequate remedies for a situation of that kind. How would a person approach the court? They would file an Article 32 petition, Manoj. They would surely. How do I even get to the stage of 142 without a proceeding? The proceeding would be either a trial court. That's why I give you the example. I filed a 32 petition in this court. In a case in which there is no consent.
Somebody like you will be able to guide them and tell them how to come to this court.
I will be dubbed an anti-marriage person. I won't do that. If somebody will say you're against the institution of marriage, I don't want that label.
Actually, if you think deeper, if we take this, why I have to claim about the legislature has not done. What is the premise? Premise says, look, don't look to it as to what I have done or she's done. Good, bad, indifferent reason, I can't live with her. Now you work out the financial terms of my not living together. Let us somebody says, okay, I'll give 50% of my personal wealth. I married, didn't work out. I want to walk out of it. The system, unfortunately, at present is not providing for it.
Because one
Halfway houses,
get into the same.
ultimately you have to negotiate with the wife and get a consent decree. So now, of course, things are changing, society is changing, but sometimes you had a case of a person coming, ultimately,
But no
he came, by the time he was 70 and she's 70 or late 70s. Why do you want to divorce? He said, no, I don't want to carry this burden of the marriage. So what you do is, I don't want to carry the burden of the marriage. We have not lived together for 30, 40 years. Why do you want to remarry? No. What is it? I don't want to carry this tag with me.
I understand. Well, there are answers to that.
So many different scenarios which are possible.
Yes, it's different. It is different, Willow. And that is why this court has granted divorce by mutual consent, has allowed petitions under Section 13B to be filed directly in this court, but only where there is litigation which originated in the trial court.
So far, yes.
Not directly in the Supreme Court under 32.
Even if one party has not agreed, divorces have been granted. I am party to those orders. Reasoning, I remember, Nagavattu argued a matter before me.
Well, not let me tell you, some of the
What she
issues are
argued
going
that
to
you
come
can't
for
grant it
you.
without.
No, even the Shivashankaran judgment, your lordship's judgment. Yes. Yeah, it's there.
Divorce in that case.
But
I think it's 20.
Ms. Jaising also referred to that Shivashankaran judgment.
I
Shivashankaran.
think it's Shivashankaran.
Shankaran is already.
Yes. I had argued for Shivashankaran in that.
The compilation series,
Page
item number
222.
21.
Page 222, Manoj. It's there.
No. Yes.
Page 222, yes.
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 I remember correctly, Mr. Nagmuthu was one of the
He
counsels.
was on the other side. I had appealed for the
You were on the
petition.
other side.
Yes, my lord. I was for the petitioner. This is the matter where your lordships were referring some time ago that the man had married in between and the lady wanted to continue the status despite the fact that the earlier marriage had failed.
Now that your lordships on that, serial number 19 also,
Yes.
My Lord Justice Kaul was a party to the judgment, but the judgment was authored by Justice Shah.
Srinivas, that's
Serial
laid
number
out.
19. Srinivas Kumar versus Shameta.
Amita.
Yes.
Yes.
So there was no consent, but power under 142 exercise was granted, holding that as an irretrievable breach.
Well, look, that is why I said the question of consent is not relevant when a court is exercising power.
No, but we want to frankly settle the law because different views have been followed by different benches and the council still raised the issue. That you can't do it. So only we can settle it first.
Yes, there are earlier views, at least two judgments which says that if there is no consent, you can't grant it because you know irretrievable breakdown of marriage.
Well, look, that's
Let
the
me
advantage of being before a bench of 5 judges.
Absolutely, that's what I
Absolutely.
Second is so that this
One
divergence
is
is
at
another
liberty to say that we don't agree with some judgments.
Even under 13B, after consent is withdrawn, orders have been passed.
Actually, take you to the development of the law on irretrievable breakdown, even in the UP, at least common law countries, which we know that such a law exists. And well, right up to 2022, So I hope I've made myself very clear. What I'm saying is there are always proxy indicators to whether the man, I'm calling them, for want of a better word, I'm calling them proxy indicators. So cruelty, or desertion, adultery, a separation for a prolonged period of time, litigation and counter litigation, these are all proxy indicators for the irretrievable breakdown of a marriage. That is the argument that I'm making, below.
Yes.
So that is why I'm saying with cause and with fault are two different things altogether.
Understood. We appreciate what you say.
But, yes, no. But just on an aside, it's not really. But since this question was put to me, that what if two people say we just don't want to live? I was going through Halsbury's laws of England in a country which has a people breakdown of marriage. Of course, my volume is very outdated, but your judges' library will have a more modern volume. But there is a entry under 417 which says the court must consider the effect of the respondent's behavior, whether such behavior is voluntary or involuntary, or the particular of the petitioner. The involves consideration not only of behavior of the respondent, but also the character, personality, disposition, behavior of the petitioner. A party's disinclination of boredom with a marriage does not entitle the court to give a decree. This in a country where irretrievable breakdown is. So, my lord, it's not. I'm not arguing. Tomorrow can say, look, I got married voluntarily, but I just don't like his face anymore. I wish my husband was more handsome. That's not the argument, my lord, that I'm trying to make. And that is why I said,
Check up before marriage.
yes. So that's why I'm saying just in law distinguish between these two. Because the expression irretrievable breakdown of marriage is nothing more than a compendious expression which describes the state of the law.
Actually, if I might.
That's what it is.
Attached to
So we need
an inquiry into an irretrievable breakdown of marriage. And that inquiry, in the absence of any other proceedings, I'm endeavoring to give an answer to my brother's question. Any expression here, reasonable methodology, solving a marriage without first being an inquiry. Right? For the fact-finding inquiry, where parties are contesting.
there is a
Therefore, so that fact-finding inquiry will necessitate at least one court. Maybe cases where they said trial court has gone into a fact-finding, fruitless to go to the High Court. Then the High Court is also an appeal court on facts. So the only negative aspect of this thought process is, in the absence of irretrievable breakdown of marriage, you have to go through this process of fact-finding and come here. If we accept your contention,
yes, it is.
then after that fact-finding, it can be done at the first level, and after a second appellate find, it can be done. That's the only way I could think of constructing it.
Yes, my lord, it is, what I'm saying is parties need not have to wait for exercise of powers under 142. What I'm saying is if the indicators exist,
Yes.
if the indicators exist, my lord,
That
then it can be done.
indicators is an aspect of fact-finding.
Yes, it is, my lord. And what is, actually they call it the duty of the court to attempt a reconciliation. Why? To give emphasis to the word irretrievable.
In fact,
Each
this,
word must be given its due
I
weightage.
tell you, this is one field of matrimonial disputes where I'm aware of the Delhi High Court at least, where the pre-litigated mediation also takes place. I'm actually aware of cases where things have gone wrong, and I must say, I've known people, I would say, please go there, Why don't you try it? And they have worked out a method of divorce, or they have worked out, most cases are working out this nitty-gritty financial that you are saying. That look, two people can't live together, now what are the terms? So the mediator works out a viable arrangement for separation.
Look, but I must point out, there is one case of this honorable court, a rather unusual but interesting case, where the court granted a divorce on the ground of pleadings. The husband alleged that the wife was a serial adulteress. And the wife alleged that the husband was mentally unstable. And the litigation was going on. The trial had not taken place.
The two allegations against each other itself makes it a irretrievable breakdown.
Yes. On pleadings, the court came to the conclusion that this marriage is over. Lord, I want to read the judgment because it has a lot of interesting, one agrees or disagrees, but Lord, that's really up to this court to decide. At page 47 of the compilation, the case is Bhagat versus Bhagat. I'm sure many of your lordships will know about this case already because it happened in Delhi. Basically, Milon, these are indicators. Page started at the trial court, transferred to the High Court for trial, didn't work out, didn't succeed, transferred by the Supreme Court to the Supreme Court. And then the Supreme Court granted the decree because they said, look at the name. That these. So, my lord, first of all, you know, at page 342, internal 52, in the middle of para 7, your lordship will find that she reiterated that he was mentally unsound. At the end of the page, suffering from mental. And yes, Lord. And at page 53, she says he was a lunatic with a streak of insanity running in the entire family. And then, my lord, para 8, it is submitted that it is only trying to defend her honor. She was said, I made these allegations because I disapprove the unfounded allegations. And my lord, this famous thing, it is said that marriages are made in heaven. It may be so, but this one has turned out to be a hell for sure. The allegations of the counter-claims are indicative of the intense hatred and rancor.
Very interestingly,
any reconciliation is out of the
very
question.
interestingly, when you're reading para 8 on a factual matrix, just read the respondent has only been trying to explain that several serious are products of sick mind and mere figment. He submitted that her children, even the sister and mother of the petitioner, are siding with her in this dispute, that the petitioner alone atoned from the entire family in prosecuting her. If the evidence would be led, all others would stand in the witness box in favor of her, who are relatives of the husband.
Yes, that was her claim. Then, my lord, at page 10, but none of these were subjected to any scrutiny.
Yes.
Page 10, para 10.
Whether you prove or you don't prove, if this is the feeling towards each other,
Yes.
you are right, what is left to the of it?
So it was an indicator, my lord. It was an indicator that what.
The indicator, there's a case you sent to a mediator, actually. Most times this was not so active. You send it to a mediator that, look, if they stick by these allegations, then what is left in marriage?
Yes. Yes, my lord. Very, my lord, if I may say, this court appears to have a trend in which they encourage compounding of offences under 490. Though under a different procedure court, it's not a compoundable offence. Now, my lord, I take it that the policy behind that is to see whether things can be settled by the ending of that litigation, where parties have agreed that people settle the dispute. We do not believe that criminal litigation should be initiated in order to settle a dispute. But I can tell you that absent a regime of matrimonial problems, women have no choice. Why? Again, one day that case will come before your evidence. We're not trying to find it for a very long time. What is the validity of saying? How does one interpret the Hindu Marriage Act on the question of alimony? What exactly does it mean? Does it mean that you're willing to give equal distribution of property acquired at the marriage? You will see a that are
Holding the very apart from in the back of the mind, there is no. So say he goes into penury, he doesn't earn anything, nothing happens. The wife will make reverse allegation saying all the wealth of the family, everything is owned by him only. Give me everything. So, in absence of probity or issues of evidence, to do some kind of some interest. There is no other option. In the same way in maintenance, you have to look at the income tax return, but you also know that sometimes these are not reflections of, so while even granting interest, there is some value judgment which we have passed or some kind of, where you say no, this man must be, this is his access broadly in the field, he must be working. Go by income tax return. I've lost my job. I've had on the reverse ladies saying, look, qualified ladies saying, I've given up my job, I don't want to work. Now give me on the basis that I don't want to work. It's also not an acceptable situation. So, social issues.
Well, at the end of the day, it's very difficult to sit in judgment over what goes on inside the home of the marriage. It's very difficult to say you are at fault, or even to evaluate their behavior. So much is a matter of personal perception. That's why it's a this relationship in the realm of the intimate.
You can't say where it began. It's very difficult to pinpoint where it began. Maybe our perception, maybe A has done it, but the fact is that B may have said something or done something which may have triggered it off. The trigger continues. Nature is everything is behind. Ultimately, the relationship is broadly behind four corners of the house and the closed door. You're not going to find. I agree with you.
So, Milan, I'll quickly finish with.
But in this Bhagat versus Bhagat, madam, in Bhagat versus Bhagat, the court dissolves the marriage on the ground of cruelty. Have you seen that?
Yes.
In Bhagat versus Bhagat, court records a finding that there is cruelty. And under section 13, the marriage is dissolved.
Yes, my lord, yes. And that is actually something that I would commend for acceptance, my lord, in the sense that you don't really need 142. And that is why the question of consent is totally irrelevant, my lord. It's totally irrelevant. Because at the end of the day, the judge is the arbiter of that dispute. There's always going to be lack of consent, always, invariably. But how do you deal with a situation where there's lack of consent? Ultimately, someone takes a decision.
It's a matter.
Everything is changing
This
to the
matter was
extent.
argued in person by reasonably eminent counsel himself in his own case. The Bhagat person.
In the High Court, not here, in the High Court.
In the High Court, it was argued. It's a well-respected lawyer's case and both sides well-respected.
Yes, they do. My Lord, but one essential safeguard, and I'll leave it at that. My Lord, even this judgment actually, let me tell you, my Lord, how I see the issue. There is no time to explain it, but I will put it in a few words. My Lord, it is like
Yes.
my Lord, as I see it, and this judgment has glimpses of that argument, and there has been an evolution of the law on how you interpret cruelty at all. And I'm suggesting that we interpret it more and more liberally. It is not cruelty in the sense of torture, etc., etc. No. So, and there is a discussion in this judgment of how the legislature, while amending the Hindu Marriage Act, in 1976, dropped some words such that it's impossible to live with the other party. Those words were dropped. Those words existed in a decree for judicial separation. So, the suggestion that I'm making is there's been an evolution of the law relating to how to interpret cruelty as well. The Lordship will see that, my Lord, at para 40.
The vintage of time of this case was a little different. So, society was. Today it's gone further on. But even then, while granting on cruelty in para 21, an ultimate paragraph.
Yes, my Lord.
So
And my Lord,
that,
I really would like to commend this.
Though it is on the theory that
Para 21,
while
22 are
scrutinizing
very important safeguards while granting a decree. May I read them, my Lord, with some emphasis, with all the emphasis at my command. Before parting with it, I think it's necessary to append a clarification. Merely because there are allegations and counter allegations, the decree for divorce cannot follow. Nor is a mere delay in the disposal of divorce proceeding itself a ground. There must be really some extraordinary features to warrant grant of divorce for the basis of pleadings.
Yes.
Not divorce on the ground of irretrievable breakdown.
Okay. And other admitted material.
Admitted materials without a full trial. Irretrievable breakdown of marriage is not a ground by itself. A lot of emphasis on the word by itself.
Yes. Now, next sentence is important.
But while scrutinizing the evidence on the record, determine whether the grounds alleged is or are made out and are determining the relief to be granted, the said circumstance can certainly be borne in mind.
That's what I said.
The unusual step as the one taken by us herein can be resorted to only to clear up an insoluble mess. The court finds in the interest of both parties. Now, my Lord, I want to just point out 22, the petition for divorce pending in the Delhi High Court is withdrawn to the file of this court and is allowed. The allegations leveled by the petitioner against the wife are held not proved. The honor and character of the respondent wife starts vindicated. My Lord, I commend for your Lordship this formula for acceptance in cases where your Lordships have come to the conclusion that the marriage has broken down. Because it's also necessary.
So that certainly you take it if we accept the principle and we have been following it and will be followed and in some way expounded by us. That when we are doing so, we are saying that things are not worked out. We are not attributing any.
Yes, so the decree should not result in any civil or criminal consequences for either party.
Often, where divorce cases, how do we do? There are divorce cases already pending, not a mutual consent with allegations. Taking the application mutual consent in, that petition shall stand withdrawn. All allegations stand withdrawn. So that first chapter is the whitewash of the allegations. And then the power is exercised.
That can
Quite a smith.
the parties agree to file under 13B, to withdraw all allegations and file under 13B.
No, even where we have exercised powers under 142, with one party not consenting, we made sure that the allegations do not stand up.
Yes. That has also happened, my Lord, in petitions in this court. There's a wide, my Lord, initially the only dispute was whether the 6 months waiting period.
That was more limited.
That was the only issue the court was considering. Then the court went on to consider whether the 18-month period you can grant a decree when one of them withdraws, but after 18 months. And those are the type of cases that came to the court. But there are also cases of the 142 where divorces have been granted without the consent of one of the parties. And your lordship will find in this case there is not even a reference to 142 in Bhagat versus. It's an ordinary matrimony dispute.
Because the decree was granted
On cruelty.
on one of the specified grounds in the Hindu Marriage Act, but yet in some way covering up the concepts of allegations. See, look at the time period is different, 94 and 2022. Huge social change, 18 years is a huge time for a social
28
change.
years.
However, we have to think of their, I think, ability to do innovative thinking when the society was different in 1990.
Yes, well, also, if your lordships are inclined to take the view that such decrees can be granted, obviously your lordship will put certain indicators in place
Yes.
and certain safeguards.
Yes.
So that's why I call them proxy indicators, that they are actually indicators which are telling you that the marriage is broken down. That's the way to look at it. Now, my lord, I would like to take you to paragraph 22 of my written note to give you the evolution of the law, because this is where I come to the conclusion that irretrievable breakdown is a compendious expression for divorce with fault. Now, my lord, let us look at what happens in other common law jurisdictions. Evolution of the law of irretrievable breakdown of marriage. In the UK, the Divorce Reform Act of 1969 introduced the language. My lord, please note, I'm being very specific with the use of my word. I'm saying it was the language of irretrievable breakdown of marriage in section 1 and 2. But look how it read. After commencement of the act, the sole ground on which a petition for divorce may be presented to the court by either party shall be that the marriage is broken down. Now, subsection 2. The court hearing a petition for divorce shall not hold that the marriage has been broken down irretrievably unless the petitioner satisfies the court of one or two of the following facts: that the respondent has committed adultery and the petitioner finds it intolerable to live with the respondent; that the respondent has behaved in such a way that the petitioner cannot reasonably expect to live; that the respondent has deserted the petitioner for a continuous period of not less than 2 years immediately preceding the presentation; that the parties to the marriage have lived apart for a continuous period of at least 2 years immediately preceding the presentation of the petition, and the respondent consents to the decree being granted; that the parties to the marriage have lived apart for a continuous period of at least 5 years immediately preceding the presentation of the petition. A petition for divorce shall be the duty of the court to inquire as far as reasonably can into the facts. Every word is significant, and I would emphasize it. To inquire as far as it's reasonably possible. This raises the question of standard of proof, Lord.
Now, the condition is fairly stringent, because if you look at E and E, the parties to the marriage have lived apart for a continuous period of 2 years immediately preceding the presentation of the petition, and the respondent consents to the decree being granted. 1. Number 2, the parties to the marriage have lived apart for a continuous period of at least 5 years immediately preceding the presentation of the petition.
Yes, Lord.
It's fairly stringent.
See, when you talk about here under this act, irretrievable breakdown of marriage, you can only claim this in the absence of consent after 5 years.
Yes.
That's the little stringent condition.
All those waiting periods are put in the hope that there will be a reconciliation.
And there is another aspect to it. In that society, normally both the spouses are working. They work.
It's true.
It's the normal route. It's normal.
Yeah.
Yes, working parents. Working
Indication from the
partners.
transfer petition letter here that
Hello. To be honest, this statute has undergone amendments any number of times, and some of these periods have been shortened, not shortened. The reason I put it on record is to show that despite the factors that exist, they use the expression irretrievable breakdown. So there's a lot of significance to that, my lord, that it is a factor to be taken into consideration when certain facts exist. And that's why I repeat, my lord, these are really only pointers to the breakdown.
So you think, and in the transfer petitions which we have seen, if I can say, more than 50%, then I would take that as indicators of failures of marriage, because those are coming being launched, are within the scope of 0 to 3 years marriage. It's a very high percentage of the petitions coming forth before the courts are in early years of marriage. I've seen same day, I've seen 2 months, I've seen 2 years, but a lot of them are in the range. I would say almost about 50% would be in the range of 0 to 3 years of marriage.
Yes.
So that's why, and I looked at 5 years and thought,
Unfortunately, in this country, there are not enough empirical studies. But in the UK, before they passed these laws,
must have done their own.
they commissioned Royal Commission reports on what are the patterns of divorce, what are the reasons, what are the causes, what are the consequences. But what happened here in 2010? We just introduced a bill in Parliament, irretrievable breakdown, without any empirical data as to what are the consequences.
Empirical study we don't do. I've been emphasizing judicially legislative impact studies. Just bring in legislation without any legislative impact studies. It's a great problem. The consequences are felt after the legislation comes.
But, my Lord, with respect, I wish to say that the law in this country is changing. After the passing of the Prevention of Women from Domestic Violence Act, we now recognize non-banking unions as deserving of protection of the law. It says that it's an act which extends not only to married women, it extends also to people who are living in a relationship in the nature of marriage, which was intended to bring in civil unions or of a conjugal nature. And this court has explained what is the meaning of that expression, relationship in the nature of marriage, basically by saying there has to be conjugality. It's also changing. That is a very major factor, my Lord, that the Lordship will have to make. Indeed, I can make bold. Higher into the case so far as reasonably can. What is the meaning of this so far as you reasonably can? Because there's a point beyond which you cannot inform the case.
Personal.
Yes.
Can't get into this
Yes.
relationship.
And look, there is also case law. I can point to it. There was a time when judges were using proof beyond reasonable doubt in matrimonial proceedings in England. In England, it's there, all reported judgments law. Then a court had to step in and say, sorry, matrimonial proceedings are not criminal proceedings. You have to use balance of probabilities to decide. That is why I'm emphasizing this word so far as you reasonably can. So, my Lord, really the suggestion that I'm making, which I will sooner or later put it into writing, is that give a liberal interpretation to section 13. Read into it irretrievable breakdown when you see certain proxy indicators. And, my Lord, the nature of the inquiry is on balance of probabilities, perhaps even a more liberal standard than balance of probabilities. I would recommend a standard of perception of the people. That's been done in the case of sexual harassment. That standard is used in law. Because somebody can say, this is my perception that it is sexual harassment, your perception is that it's not.
Yes.
It's a classical case, my Lord, in which perceptions differ. So, my Lord, if you use these three legal tools, more liberal interpretation, the question of what. and a more liberal interpretation of standard by which evidence will be evaluated, where inter alia, my lord, your lordship uses the perception of parties themselves as a standard of proof of facts and circumstances, and then puts in place certain proxy indicators along with certain safeguards. I don't know whether this proceeding will indicate the precise parameters of financial relief, but that may have to await another case. The safeguard must be there.
We certainly will build into it the concept of a safeguard.
Yes, the safeguard that before any such decree can. So what I'm saying is, Lord, your lordship may not be able to give a measure of what should be given. For the moment, in my mind, I have only used the standard of living to which the husband is accustomed, which has been used in law. Until we see an amendment that says that matrimonial property should be equally divided. Perhaps, honestly, my lord, I was looking at the statistics in. There is data of how many divorces are filed every year in the country. So, my lord, can reasonably can.
Some problem is there has to be a commission document, there has to be some other methodologies to assist the court by producing. Yeah. And it's a difficult what is to be done. See, I think sometimes everything lands in the lap of the court in a personal instead of the groundwork being done. That's why we request amicus to assist us when we find that there are other assistants who are not working.
My lord, for example, this paragraph 6, I'm sure, has been amended or there is case law. But the purpose of this act, a husband and wife should be treated as living apart unless they're living under the each other in the same. So this is no longer the law. Now the law is you can live under the same household and still
Live separately.
My lord, in this subsection 5, that what is the meaning of living apart? That means you have to be not in the same household. But this is no longer the law, my lord. You can be living in the same household and yet be living apart. Even this court has held that.
Yes.
Now, my lord, I come to my submission in 2423. From a reading of section 1 and 2 of the Divorce Reform Act 1969, it is apparent that the factors such as adultery behavior in a manner which petitioner cannot be reasonably expected to live with the respondent, desertion or at least 2 years, parties living apart for at least 2 years, apart, not less than 5 years, immediately preceding present, were all taken into consideration while deciding whether the marriage had irretrievably broken down. That's why I said these are proxy indicators. But what you're looking at is there a breakdown? What is happening today under our dispensation is people are not even looking at the issue whether there's a breakdown. It thus submitted that the above factors are indicated. Now, my lord, come to the qualitative in the law. In 1973, UK passed the Matrimonial Causes Act. The Act continues to be enforced till date. However, the Act of 73 was further amended by the Divorce Resolution and Separation Act. Section 1 and 3 read as follows. Subject to Section 3, either or both the parties of marriage may apply to the court for an order of divorce which dissolves the marriage on the ground that the marriage is broken down. This is not, now you can say it's a no fault claim. Court dealing with the application under subsection must state the statement to be conclusive evidence that the marriage is and make a divorce. You can state but I'm saying that ours is not system of divorce based on it is a system of divorce based on cause. But the ultimate decree reflects the fact that the decree for divorce. I'm sure that we may not be able to, I may not be able to, perhaps I won't be able to persuade you that you should also take a statement. Because that is, at the end of the day, the judicial body looking into it. But here what they've done in England is, they've said no, either or both parties favor.
It's just taken them so many years to come to this stage. Yeah, also it will take time.
I was myself surprised, Lord, because of this confusion in the head, fault and no fault are the same, but they're
The
where you say
distinction
for
is obliterated there, but
yes, I'm surprised. In between the amendments, but this is the latest amendment now. It is generally believed that changes made in 2022 depart. However, it is submitted that it will break down cases mentioned in the original Act of 1973. It is worth noting that it will break down the consequence of pre-existing causes. That is why, my lord, in the when this court said there was seen as many of which would include adultery, desertion, cruelty, or separation of a continuous period. In other words, I'm saying, well, these are not exhaustive of the issue of it may be noted that the UK Matrimonial Causes Act engaged very clearly that every marriage and breakdown on account of group are interchangeable. And that these are factors to breakdown of marriage. Hence, a decree for breakdown of marriage can be granted in the above circumstances as seen to exist in the marriage. Periods have included, this is my suggestion, the period of separation will include the period. And it was pointed out to me by this court that in the UK they say the period has to exist prior to the filing of proceedings. But my suggestion is, the pendency of courts having regard to the enormous delays should also be taken into consideration. Another very common indicator of breakdown of marriage by initiated proceedings under 498A if they need to go to either party libel, defamation against each other criminal proceedings for cheating, all of which lead to the conclusion that the marriage is broken down. All these indicators have been drawn from judgments of this court. Then, here, I deal with the fault theory. It is true that some of the statutes dealing with divorce contain provisions to the effect that it is to be satisfied that the party is not taking advantage of their own wrong. In section 23(1), it is submitted that the context of the husband either wanting a decree for restitution to defeat a claim of maintenance. In such a situation, it may be useful to look into the question whether the husband is taking advantage of his own wrong. However, in a hotly contested matter, seeking divorce on the ground of cruelty, desertion, adultery allegations are often page. This honorable court has held that by forward, this can be not an interesting observation. Give me Gura versus Gura. Interesting observation, my lord. Deciding to grant or not answers the question posed to me. Decree on the ground of breakdown of marriage not be blown out of proportion for in isolation and granting a decree for the cause of the ground of breakdown of marriage. Now, my lord, that judgment can be found at page 63 of. It is the only judgment, my lord, that I found which could aid in the interpretation of section 23. Again, this, but I won't take you through the facts because there were again multiple the allegations you will find at internal page 68. I mean, the allegations and counter allegations that they were having pornographic relationships with other people, with efforts, etc. Then, my lord, para 9 criminal proceedings were filed.
so then his consent was filed, withdrawn. After that, consent withdrawn in the window.
Yes, multiple petitions for divorce were filed. And then the indicators are at page 75, para 19. While considering the matter in detail, we find that the appellate court had not disputed the following. Marriage parties is dead and broken down. There were allegations and counter allegations between them. There were also sorts. And love is lost between them. There is a delay in the disposal of the matter. The husband has married again and has got a child. The wife has not withdrawn her consent lawfully given for a period of 18 months. The joint petition filed in the court by the parties that the parties have settled the matter and the wife has renounced her right to claim maintenance, which the parties prayed for was only a decree for definition of marriage by mutual consent. It appears that the appellate court was not come to court with clean hands. In that he married during the pendency of the proceedings. It may be, as expressed by the appellate court, that the factor such as marriage is dead and has broken down irretrievably, that there was no chance of reunion, that there were allegations and counter allegations made by the parties, and the parties were residing separately for 13 years. Each one of the above factors by itself individually may not have photographed. This is another legal formula below that they use. Each one is not sufficient, but cumulatively they are sufficient. Here is the view that the cumulative effect of various aspects of the case in dispute is found that the marriage is dead, both emotionally and practically, and there is no chance at all of the same will survive. And a continuation of such relationship is only for namesake, and that no love is lost between the parties who have been fighting like Kilkenny cats. And there is the long on the interpretation of 23, I would recommend para 23.
Okay.
Para 23. Cannot do, we have not lost sight of the fact that the conduct of the husband is blameworthy in that he married a second time and got a child during, but that factor cannot be blown out of proportion. Similar, that answers, I hope, the question about section 23 that was posed to me. Then what do we do? We find that the party asking for default divorce is at fault. Then, my lord, it is also important that before a decree is granted, an attempt should be made to reconcile. In view of the foregoing, the answers framed by this honorable court, as quoted here and above, may kindly be answered accordingly. How it is submitted that before such a decree for divorce is granted on account of irretrievable breakdown of marriage, certain safeguards for the parties to the marriage, in particular the wife, are needed to be put in place.
Yes.
Sure, by this honorable court. But a final attempt is made in reconciling. The determination is made that the marriage has been broken down. Adequate financial provision, more particularly in wife, which is just, fair, and equitable. Having regard, I will not please note that I've used the word equitable. Having regard to the various factors such as housing arrangements so the divorced wife and children, if any, financial arrangements consistent with the standard of living to which the husband is accustomed, welfare of the children, including the housing, educational provision, marriage, medical expenses, entertainment, extracurricular activities, custody of children where such custody is not mutually agreed in the best interest of the child. And no, this is the last one I've added based on Bhagat versus Bhagat. No blame is attributed to either party as a result of the decree for divorce, which may impact future civil or criminal proceedings. Now, my lord, this is just a checklist. Now, obviously, each one of them in the matrimonial law of other countries is very highly evolved, where the statute itself deals with financial provision. And I must point out, my lord, I'll be failing in my duty if I don't point out that England does have a regime of equitable distribution of matrimonial property on the breakdown of a marriage. We don't have it. More the reason why we should be careful in putting these safeguards in place while granting such a decree. A lot of attention will have to be paid to the fact by the judges that, Lord, now there are judgments of this court and of the Delhi High Court which cast the burden on the husband to disclose his financial status. And if I may say so, my lord, in the days when black money was very common, it was impossible for a woman to prove what is the real worth of her husband. There is so much hidden wealth in this country, it's unbelievable. But my lord, my information is that after demonetization, it has gone down a little bit. The existence of
I would not pass
untaxed
judgment
money,
on that
but
issue.
how much I
Technology and methodology today are available to get indexes which give us a better assessment of the income of the husband. maybe returns, income tax returns, it may be other assets, ability to value those assets. Anything else?
Well, only one thing remains. I am keen on your lordships accepting the proposition that the right to marry and the concomitant analogous right to not to exit a marriage is a fundamental right. I would put it squarely under the right to life and liberty, read with the right to form associations. Well, at the end of the day, a marriage is an association. It is it is the right to affiliate.
One's fundamental rights are subject to reasonable restrictions.
It is, Lord.
It's
It's going to be,
principle is fine.
whether you like it or not, it's going to be a very major issue which is going to surface in this country. In a multiplicity of situations. Not that I'm arguing proxy for anything, but I need to let you know that there are petitions pending in the court where gay people have said we also have the right to marry because it's the right to affiliate. What the court will decide is not for me to say. But this is well traversed ground.
Can we step into those domains in these proceedings? Would be difficult to. I may have my own views in it, but I can step into those domains is a little difficult because then it would be really foreclosing the opportunity in those cases of this issue being debated. And
Well, I am more interested in saying that right to divorce is a fundamental right. I am not asking you to address for the purposes of this case. For the purposes of this case, my lord, what we are looking at is there a right to divorce? What is the nature of that right?
See, there is no doubt there is a right to divorce. There is no doubt there is an enactment now for right to divorce in every position. Question is where there is a cause, and the cause may be by one person or both persons or other person. As long as people cannot live together, you are saying that they must have an opportunity to part ways and live their life.
Look, like all laws, it has to pass the test of reasonable restriction. If it's a fundamental right, then like all laws, it must pass the test of reason. If you unreasonably keep two people in a bad marriage, then, my lord, I'm sorry, the law is liable to be declared bad in law. That is why it's important to understand what exactly are we dealing with. We are dealing with intimate relationships. An intimate relationship, no decree of the court can force an intimate relationship. That I'm only arguing that you must keep that in mind. But I've got a few additional submissions. I'll finish quickly before we close for lunch. But they're already in writing. I've given a volume, and I won't take you through the literature on the subject, but there is literature. And the primary additional submission, just tell it. And those additions. The primary one is, I'm just adding one more submission, and that is the right to marry a person of your choice is a fundamental right and guaranteed under 19(1)(c), read with Article 21. Equally, is the right to divorce must be considered a fundamental right, and no unreasonable restrictions can be put on it. It is submitted that the right should be protected under 19(1)(c). It is submitted that the right of association includes two rights: the right to form expressive associations such as unions, and the right to form intimate associations such as marriage and familial bonds. And there is this judgment of the Supreme Court in Roberts, which was a very interesting judgment. A club said we'll keep out women. And the law that was passed said that you can't keep out women. And in that case, my lord, they distinguished between intimate relationships and non-intimate relationships. So they said, all right, we can force somebody to become, to take a woman as a member in a club because it's not an intimate association. But intimate associations stand on a different level. So only for that distinction between the two associations, my lord, the case is known as Roberts. It's there in the compilation.
Yes, you've given it a note on it in para 2 of your editions.
Para 2.
You already incorporated it.
That is allowed on the well-traveled ground, well-traversed ground by this court on Puttaswamy. I'm sorry. Yes, Malone, there that the summary of Roberts submitted the United States Supreme Court in Roberts, where the constitutional validity of public accommodation laws was under challenge, held that the guarantee and the 14th Amendment of the United States Constitution protected, among other things, the right to marriage, childbirth, cohabitation, and with one's relatives. Such a right would also entail the freedom to leave such intimate association. This, I suppose, is my submission. This submitted that the right to form intimate association is a part of the freedom of association and 91C of the Constitution of India. The right to enter into association has an analogous right to leave in such an association without state interference. Now, my lord, this should be modified without, there is state interference in the form of the judge, the judiciary. So therefore, my lord, I would modify it and say reasonable restrictions can be imposed on the right, but not unreasonable restrictions. My lord. And to deny a divorce on the ground of irretrievable breakdown would amount to an unreasonable restriction than the right to leave a bad marriage. Then, my lord, your lordship may go through Roberts, the full text. I point that in this volume is also literature about how bad marriages impact children. That your lordship will find
Yes.
page 30, at page 31,
Conflict and the damaging effect.
and how bad marriages are also bad for the two parties in question. There is an article on that as well. I mean, to me, it's common sense, but then academics want research, and that's why I'm giving you the research.
Thank you.
My lord, I'm here in my capacity as amicus, and therefore I can only persuade you. Beyond that, my lord, there's nothing I can do because I'm not representing a client.
Doesn't make a difference.
But
We are still persuasive enough.
I have to say that your lordship have given me the liberty to express my point of view, but in my capacity as amicus.
Thank you.
My lord, there's no judgment of this court incidentally on what is the goal of an amicus. I haven't seen it. I've been looking for it high and low.
In one sentence to make us write better. Mr. Girish, you'll begin at 2 o'clock?
Yes.
Obliged, my lord, for the patient.
After Mr. Giri finishes, I'll take about 45 minutes.
Okay. How much time will you take?
Not more than 40 minutes.
Let's try to wind up today.
Very
Because
I'll convince myself.
I've scheduled other constitution benches immediately after reopening. So I would like to, I anticipated only about kept 1 day's cushion.
I would read for the judgments, but not for the compilation.
Your lordship would give us some time also.
On what? See, divide your time. Both are saying. Ultimately, it will be repetition otherwise.
Correct, we'll not repeat.
All of you seem to be, I've not had a different point of view. All of you seem to be on this basis that in different ways, please
Yes.
exercise this power.
Yes.
But I am going to be respectful
Opposite.
separately to the country.
Oh,
Your lordships cannot exercise.
Oh,
No, no.
I'm glad my learned friend mentioned that.
no, it's at least that somebody puts a different point of view. Somebody has to put a different point of view, so we have the satisfaction of.
Definitely, because the way 142 has been used by this court, it's matter of
No,
concern.
the loose copy.
From income tax, for all kinds of matters, 142 is now being exercised. And that's a matter of great concern.
Probably on the argument about fundamental right to association and then fundamental right to get divorced, we may not be agreeable with the submission, But on the question framed, we would argue that yet, yes, it can be exercised, it can be molded, it can be read into the enactment. Will be our submission.
If Mr. Dave,
One,
I try to wind up not in 30, 35
if
minutes.
you can wind up in 30,
I'll just
35
make the
minutes.
points
And
for-
similarly, Mr. Dave, if you can make an endeavor to
40
conclude.
minutes next.
I won't take.
I'm trying to persuade you to take 10 minutes less so that the others get it done.
I should have mentioned, just give me 2 minutes, delay your lunch by just 2 seconds. At 2019, 853, page 1, just make a note of the judge. It is a case where the issue was whether voice sampling can be done.
Yes.
And one of the arguments was that this would go against the right to self-incrimination. The court rejected it. But what is important in support of my argument that it can be done under 151 is this court actually said we can give this power to the court, to the magistrate court, para 22. That was done. So far as the second basis of the view taken is concerned, we have already expressed our opinion that what may appear to be legislative inaction, very important, but not in the light of Mr. Dave's submission. To find, no, because he's, I know you're yes, and I'm glad there's a contrary point of view because I can counter it. Well, I said, I'm here as amicus, I'm not holding a brief.
Just give a notice.
Yeah, let's speak.
Serious inroad on Article 20. And it's completely contrary to.
Okay, thank you.
My lord, I can tell you,
I-
many judgments in this court,
All I can say
but they are judgments of the court.
You're not depriving us for lunch.
You don't tell me what to rely on, okay? What to rely on and what not to rely on. It's not your remit in this court.
Something, apart from depriving us of earlier lunch, I have a meeting also of some concern to lawyers. We will sort out that problem.
So,
Just according to.
you know, your lordship will look at this judgment where, there's an interesting discussion on whether this is
We'll
legislation
read
or
through-
not legislation.
We will read through the interest.
Yes,
Thank you.
Please do because it can be done.
Thank you.